Member for Vieux-Fort South.
Mr. Speaker, I'll be brief. I want to assure you because I know Mr. Speaker, there are some provisions in this bill that are welcome provisions. And as someone now who's engaged in practice, one has a better sense of how these provisions actually work. So, for example, I don't think one can object to the new clauses that require a secretary of a company to be appointed within a specified period. And I think it is a matter that really does deserve correction, because it is well known that many companies are registered and it takes ages before a secretary is appointed, or assistant secretary for that matter. So I don't want to, under any circumstances, suggest that some of these provisions are not required. I think some of them are helpful, but there are some issues. I'm glad that the Attorney General is here and listening to at least this part of the debate. First, I would like to find out whether these provisions have been discussed with the Bar Association. And the reason why I ask is that I suspect the implementation of some of these provisions would be challenging. I think one of the first things to bear in mind is that there would be a major slowdown in the incorporation of companies in St. Lucia. And the implications for rankings in respect of doing business will obviously be a real one. Because if you really look at it, Mr. Speaker, if you look at Clause 3, the new requirements under 3B, by inserting after subsection 2 the following new subsections 2A to B, in determining whether a person is a fit and proper person to hold a position as director of a company, the following must be considered. Now, go through the list of these requirements. The person's probity, competence, and soundness of judgment for fulfilling the responsibilities of a director. How do you judge that? What is the evidence do you procure to judge that? The academic or professional qualifications or effective experience in business administration or other relevant discipline. What if the incorporator or the director happens to be a small business person who may not necessarily have these qualifications? What is the weight that you attach to this? Then the diligence with which the person is fulfilling or is likely to fulfill the responsibility. How do you judge that? Who judges that? Is it that the attorney who is incorporating the company provides an affidavit to the effect that in his or her judgment that the person satisfies the criteria here? And then you go on, Mr. Speaker, if you look at 2B, very quickly again, without limiting the generality of subsection 2A, the consideration must be given to the previous conduct and activities in business or financial matters of the person in question, and in particular to evidence that the person has committed an offense involving fraud or other dishonesty or violence. Again, Mr. Speaker, I assume, so maybe you will require a police record to evidence that. Contravene a provision made by or under an enactment designed for protecting members of the public against financial laws due to dishonesty, incompetence, or malpractice. How do you judge those things? How do you judge the incompetence? Is there a judgment on the person in the firm or the business to that effect? And then look at C. Engage in a business practice appearing to the board to be deceitful, oppressive, or otherwise improper, whether unlawful or not, or which otherwise reflect discredit on that person's method of conducting business. Different people conduct businesses in different ways. They have different approaches, different style. How the member for Castries Southeast will conduct the business of his company would be very different, let us say, from how the member for Castries South will conduct his business, as we heard, Mr. Speaker, from the earlier testimony during the previous debate. These are very real issues, Mr. Speaker. And if you look at item D, 2BD, An employment record that suggests that the person carried out an act of impropriety in the handling of his employer's business. Now, how again do you evidence that? When it is known that in many companies in St. Lucia, members of staff commit acts of impropriety and the businesses themselves hide the information and in fact settle it quite often, settle it privately so that it is not part of any record. So, Mr. Speaker, I'm not in the business of recommending changes to legislation anymore. I'm done with that. All I'm saying is that I believe that there are some very serious practical issues to operationalize these provisions, necessary as they are. Now, Mr. Speaker, let me just very, very quickly turn to one other matter. Some time ago, the House enacted legislation requiring declaration of beneficial ownership of shares when you're registering a company. Since the passage of that legislation, I've had the opportunity to register companies, and I can tell you, it has not been easy to understand the procedures and how the procedures should apply. I don't know whether the Attorney General might not want to reconsider the approach dealing with the beneficial share ownership. In other words, maintain it, by all means, keep it, because we have to satisfy the requirements of the OECD. But one of the questions that will arise is really whether the declaration should be a pre-incorporation one or a post-incorporation of a company. I mean, if you're registering a company with a sole one director, then almost immediately the suggestion of beneficial shares is at first glance rather remote. And maybe the problem could be resolved if there's a general provision to introduce a basic format in dealing with this issue. So I think that these provisions are necessary. They're helpful. I don't see many members of the bar objecting, for example, to the timelines to appoint secretaries and the like. I think everybody understands that, the necessity of that. But I believe the actual application of some of these provisions will be weighty, will be confusing, would be difficult, and I strongly suggest that we have a different approach, because what this will eventually lead to is a serious slowdown of the incorporation of companies in the country. I think we need a little rethink, and perhaps it might be a good thing to have some discussions with the bar. Maybe the discussions have been held. I don't know. It's quite possible. But certainly, from a practical point of view, I envisage challenges in implementing this. Thank you, Mr. Speaker.